everyone. This is Kim Coghill with ACA International, the leading voice of the accounts receivable management industry. The content provided in this podcast is presented for educational and general reference purposes only. The content is not intended to serve as legal advice. Before we get started, I'd like to remind you that registration is now open for ACA's Spring Forum and Expo, March 11 through 13 at the M Resort in Las Vegas. Please visit our website at www.acainternational.org for additional information. So today's episode of ACA Cast features two veteran healthcare industry professionals who will discuss the future of billing practices for healthcare providers. We'll hear from Irene Hoheusle, Vice President of Collections and Education with Account Recovery Specialist in Wichita, Kansas, and Tim Haag, President of State Collection Service in Madison, Wisconsin. So this podcast is a follow-up to a really successful session that we had at ACA's Fall Forum and Expo, in which Tim and Irene addressed these topics. So, Irene, we are sure that everybody is aware of the Consumer Financial Protection Bureau's released proposed rules on debt collection. So as we await the final rules, is there anything about the rules that you believe is problematic for our industry?
Well, thanks, Kim, for that question. The problem is you're only giving me a few minutes to talk about this, and I can talk about it for hours. So do I have any problem with some of the things for medical debt collections? Yes, definitely. But I'll touch on what I think is some of the most serious things. For the medical industry, the model validation notice could be a big problem with what they're saying. The NPRM wants us to put more itemization on that validation notice. Now, in their own words, somewhere else, if you want to look at the rules on page 397 on the NPRM, but they mention that there's about 16%, they recognize this, about 16% of all validation notices in our industry reach family members. Now, they're not even talking about strangers. They're talking about they reach family members. So we know about 16% on average are going to wrong parties. If we have to include more validation language in those letters, then we know we're intentionally disclosing protected health information to at least 16% of the population, which is bad because we have to follow the Health Insurance Portability and Accountability Act, HIPAA. Anybody who does medical collections is very familiar with HIPAA. According to HIPAA, we have to secure protected health information, which would be everything in a patient's healthcare file. If we use means to intentionally send information to third parties, we're going to violate the Act. And any violations that we do is also reflected on our clients. They could be fined for that too, especially if it's intentional. Where it becomes really difficult is because with the medical industry, oftentimes we collect bills that are for multiple dates of service, that have multiple things that have happened to it with multiple insurances. So itemizing that could be extremely lengthy, especially if you have a doctor's office. A lot of doctor's offices, they do what's called family billing, where they put the entire family on the same account, and it could be years and years of multiple services. That's going to be very difficult to itemize on a bill. But the truth is, if there is any question from the patient, from the consumer, all they have to do is ask, and we can get that itemization for those that ask without putting it on every single validation notice to make that protected health information now become a not secure means of communication. So that has been addressed. And I'm not even mentioning the burden that's going to put on our medical provider clients because, to be honest with you, and I'm sure Tim could even share his view on this, most of our consumers don't ask for validation of debt. It's really a very small percentage on medical debt that actually ask. And when we do, we get it and we send it to them, no big deal. But most people recognize what the bill is for. They know they went to the doctor. They know their family had surgery, or someone had surgery or got in an accident. They know what it's for. It's very rare they don't. With that said, why are we burdening our clients to try to get all this information to us, burdening the agencies to try to get all this information on the first validation notice, and then sending it to people that, like they're mentioning, at least 16% of the time reach third parties that are family members? I see that as a big problem. So there needs to be some consideration of the HIPAA rule, the minimum necessary rule, in the model notice of these medical bills. Now, I can go on and on about other things that need to be tweaked, but I'm going to suggest something. If you really want to know suggestions of what needs to be tweaked, go and pull out the ACA 154-page comments that they made during the filing period because they hit on everything, including this. Tim, is there anything that you think also with that question that's going to be a problem for medical collectors?
I agree. I mean, today, obviously, we don't have to put a box at the bottom of the validation notice giving the consumer or the patient the ability to dispute. So I agree. I mean, we do see people that do dispute, but when you put it right in front of their face And as you said, you know that you went to the doctor, you know you had this bill. Now, if I can check a box and send it back in saying, first off, let's just going to delay the process because it's going to come back to us. We're going to have to go back to the client, get that information, send it back to the consumer, and then that process starts all back over. So really it's going to delay it. Money's going to come in at a later time because obviously we will be able to prove that it isn't a dispute, but having that box, the ability to check that box just delays it for that patient. So really that will be very problematic in my opinion.
A problem also with that little checkbox that they have down there on the model notice anyway. I mean, I hope this has changed, but if you look, they give options, and all of the first options are basically dispute, 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 and then they say, okay, I'm going to pay this. And there's no way for them to say why they're disputing. Now, I know all of us, when we get disputes, we want to know why, because we don't want to have collection activity against a person who truly doesn't know the bill. We don't want to report on a credit report invalid or inaccurate information. But if we don't know what the dispute is, if we don't know the reason for their dispute, how are we supposed to properly investigate it? And if you think about it, with medical bills, there's so many more reasons that people dispute. I mean, if I had a credit card bill, I could say, well, I didn't charge that. But medical bills, you got, this isn't me, I'm not responsible for my child, she brought the child there, I have insurance to cover it, I have secondary insurance, go after the person who hit me in that car accident, this is work-related. I mean, there's a million different disputes. It could even be the simple one, I already paid this, or this balance is wrong, or anything that's very easy to determine if it's a valid dispute or not. But if we don't know why, we don't know where to go. We're basically guessing. So to Tim's point, what I think happens with that is not only do we maybe investigate the wrong reason, but there might be a valid dispute. And if they're not giving us information to tell us what the dispute is and we're not noticing what their valid dispute is, we're going to continue to credit report, we're going to continue collection activity on something that maybe we really shouldn't. So if they're going to put that stuff in there, and this is what I've said in my responses to the notice proposal rulemaking, if you're going to put that in there, I know you're limited on space, but you have to word it in a way or give an area or give a place that instructs them to put the reason for their dispute, so at least we'll have a little less of a conundrum when we come down to time to searching and figuring out what their dispute is. You agree with that, Tim?
I think the other good point here is what this promotes is it promotes communication through snail mail. And we know today that doesn't work well. Ideally, if somebody's going to dispute the account, to your point, we want them to contact us. If they have any questions, we can talk through it. In our company, with our healthcare clients, even on the bad debt side, we have a lot of system access. So we can go in and review the notes, review everything within that system, and really talk through that with the patient. So we don't have to go through that dispute process. But if I can just check the box and mail it back into you, it gives you no reason to want to contact us. If you contact us, we can resolve your situation and prevent you from your credit being hit or filing suit on you or anything else like that. I think the letter should state, for a dispute, please call and talk through this dispute rather than doing it through mail communication.
Right, I agree, totally agree.
Another area that I wanted to just touch on was the consent tracking, and this is something that we've always had to deal with and we're going to continue to deal with. Today in healthcare, I think they do a really good job of gathering consent, and we do have healthcare providers that will provide us in the file a field that says, yes, they've signed consent, but they're very poor at coming back and letting us know that they've revoked that consent. And I think other industries are well ahead of us compared to healthcare, but the admissions office doesn't understand how important it is to get somebody to sign that consent, but more importantly, to be able to report that back. There's one particular healthcare provider that we work with, and we actually had one of our employees actually goes to that hospital, and when they first brought out their new consent language, I think it was about 2 years ago, the question at the front desk was, oh, sign this piece of paper if you wanted to get random emails from time to time. They made it sound like it was going to be for like, you know, just advertising or fundraising or things like that, not for the purpose of actually communicating about your financial responsibilities. I think that's an area that we'll need to continue to work on with our healthcare clients in order to educate them, in order for them to understand the importance of getting us back any patient that has revoked consent.
You know, it's funny that you bring that up, Tim. One of the things I do in some of my seminars with my clients is we go over consent forms and the reason for them and what they are. And the thing that I tell them is your staff is not an attorney. It's not an attorney giving legal advice to these patients. And when they hand over a consent or an admission form and they say, sign this, and usually you'll have like, we'll sign this so we can bill your insurance, because there'll be language on that consent form to bill their insurance and for the insurance to pay, you know, the medical facility directly. When in the meantime, there's a whole bunch of other stuff on that consent form. It's not just consent to treat, it's payment, it's a whole bunch of different stuff. And I tell them, you're not an attorney. That's a legal document. They're signing a contract. They're signing and dating a piece of paper. Your staff should not be saying, this is sign this so, like in your case where you say sign this so, and that's not a good thing. What they should do, they're not attorneys, they shouldn't be practicing law. They should simply be saying, I need you to read this. If you have any questions, get back to me and please sign it when you're done. And if the patient chooses not to read it, that's not your fault if they just sign it and give it back to you, but that should be the instruction they're giving. And when they ask a specific question, like, well, what does this mean? Well, that means you're responsible for payment for whatever insurance has to pay. Well, that means that you'll be getting email communications. That means you're giving permission for the doctor to treat you today. Whatever it is, you can go and you can address that one line instead of trying to go over the whole document.
Completely agree.
Okay, Tim and Irene, that was fantastic information. So I have another question. Are there any new or troublesome trends related to how our industry can communicate with healthcare clients?
Well, yeah, I'm glad you asked that because, you know, we just got done talking about some of the negative impacts of the new proposed rules, but I think we can all agree if the proposed rules related to communication do come out as they were proposed, we should have some big wins. And I think the big wins there are, we kind of talked about the day of communicating with snail mail or U.S. mail is in the past, and what consumers really want today is to be able to self-service. In order to self-service, the use of email and text is going to be crucial. In today's world, the younger people don't want to talk to us on the phone, and they definitely aren't going to go down to the post office and get a stamp to send in a payment. So the ability to be able to use email and also text messaging, we've experienced this today on the first-party side and have great responses when we're able to do this. The stats that show that I think it's somewhere between like 90 to 95% of the time with a text message, they respond within the first 5 minutes. With call blocking out there today, that has decreased our chances of being able to reach a person by telephone. But even if we do get their phone to ring, 9 times out of 10, they're not going to pick up a strange number. I mean, even myself, I get a lot of phone calls. If it's a number that I don't know, I let it go to voicemail, and hopefully they leave a voicemail. And if it's somebody I want to talk to, I'll call them back. But again, on a text, I would respond, and same thing with an email. I think those are the very positive things that we have to look forward to. I think the only troublesome ones, they limited the number of calls to 7 attempts. Even on the consumer side, they thought 7 was way too much. It's not 7 contacts in a week, it's 7 attempts. In our agency, we don't overcall people, and we've never been known to do that. Just having 7 attempts just to try, I mean, we obviously try different times of days and things like that. That could be troublesome. My guess is that 7 might actually come to a lesser number. And then there's a little bit of uncertainty. Does that include, if I send a text message, is that counting as one of the attempts? Same thing with an email. So if I send them a text and an email, now am I limited to just 5 attempts by telephone? Irene, your thoughts?
I agree. And when it comes to medical, that even is harder for us, because another thing that it says in there is per count. I know what they're trying to say, but think about it. With the medical industry, how many accounts do you have? If you go to the hospital and have a cesarean section, you could have 5, 6 different creditor clients sending you a bill, to the anesthesiologist, the hospital, the doctor, the pediatrician. I mean, the list can go on, all from the same date of service. Someone who wants to abuse this, if they're looking at 7 times per account, you know, that could be 35 phone calls if you have 5 accounts, 35 attempts, which does make it difficult. So they do have to clarify it, especially when it comes to medical, where it can wind up being overburdensome to those that want to abuse. And I'm afraid, like Tim said, he doesn't overcall people. Our agency, we have a one-and-done deal. We don't call anybody more than once a day unless they don't answer. We'll leave a message. They may call in the late night, but that's really it. And that's been our rule since way before any of this stuff started. And if we reach somebody, we never call them back without permission. Like if someone says to us, hey, I'm in the car right now, could you call me later? We'll ask what time, we call back. So without permission, but we never repeatedly call people. That's just abusing and harassing, and we know it. So they do need to tweak that rule to make sure, especially when it comes to medical bills, that they're recognizing that number could be huge, but also recognizing, for the most part, that number might be too small. So maybe phrasing it different, putting it in a different context, putting caveats on it, saying unless. And I hate that they use the word reasonable. Now, I know that sounds like, well, why would you not want them to use the word reasonable? Because reasonable is not definitive. It's how a specific industry person, agency, lawyer defines the word reasonable. I might think reasonable is 2. Someone else might be reasonable as 7. Now you have an argument. So I'd like for them to actually define it even more, but put more in it to clarify what that means for the medical industry.
It is possible we might have 3 or 4 different phone numbers that we're trying to reach them from. You know, they could have a cell number, they could have a home one, they could have a work number. There, if I just make an attempt on each one of those, there's 3 calls right there. And on the flip side is, as you mentioned, Irene, if you do get a patient on the phone, maybe they are at work and they say, hey, I need to take care of this tonight at 6 o'clock. Well, now, if I make that other phone call, that other attempt at 6 o'clock, that also is counting towards that one of those 7. So I'm not overly concerned about that because, like I said, and I think it could be troublesome, and I think to your point, too, going back to those number of accounts in healthcare, it's not uncommon for us to have somebody that has 20 or 30 or 40 accounts, and so it could be abused. Yeah,
could be abused. You have to be careful.
But I'm just really excited about the ability to text and email. That'll be a game changer, and, you know, we see more and more year after year payments coming through our online portal. People don't necessarily want to talk face-to-face with somebody, and if I can go ahead and take care of my balance by just using a credit card or a check online, we're seeing upwards of 10% of our total dollars from healthcare coming in our online portal. And now if I was able to email and have a link directly to that or send a text with a link directly back to our portal, it would just drive more and more of that. Again, it goes back to self-service. That's what everybody's looking for today. You know, you go into even a Panera Bread today, and you might have one person at the register, and they'll have about 5 or 6 or 7 kiosks. And you watch the number of people that just skip over the counter because they don't want to talk to somebody face-to-face, and they feel that their order will be correct if they actually do it themselves, you know, on a tablet or a kiosk.
Yeah, it's kind of scary how face-to-face contact seems to be more and more not the norm, and everything through electronic. But I totally get it. I have 30-year-old daughters that they'd rather text than call. I still pick up the phone and force them to talk to me, though. So still got the old school going there, whether they like it or not.
I have a niece and nephew that are. My nephew just turned 16 yesterday. Tried to call him to wish him happy birthday. Nope, didn't answer. Texted him. He actually responded. But at Christmas time, I constantly ask them what they want for Christmas. They'll never respond. I think it was 2 years ago I finally had to have my wife send them a Snapchat to get responses back of what they wanted for Christmas because they wouldn't even respond to a text message. So who knows? Maybe that's where the industry's going next, is sending people Snapchats.
Yeah, and especially when it comes to the medical industry, it is a little bit different. The bills are created a little bit different. They're not created out of desire, they're created out of necessity. These are people that are probably going to go back and revisit the same doctors and the same hospitals, so our clients are worried about repeat business and how they look in the community. So all these things have to be considered with every communication that we make to keep our clients happy, the community happy, and make sure that the patients are serviced correctly.
Yeah, and I think historically you make a point about healthcare bills have always been known as being confusing. A lot of providers are starting to con those, but I think you made a point earlier. If you go in for a procedure, it's not uncommon to get 5 or 6 different bills for that one same procedure. And now combining bills and having a single statement has helped a lot. If I have that ability to send an email or a text while I'm talking to you on the phone, I can send you that exact bill when you get on the phone with me and say, I never got that bill. Well, you know, let me have your cell phone number. If you allow me to text this to you right now, we can talk through it while we're on the phone, or let me send you an email. Our objective is anytime we get a patient on the phone is not to ever have to communicate with them again, just trying to resolve that issue on that first call resolution. So I think that would also be a big benefit.
Okay, thanks, Tim. So before we close out today, let's talk a little bit about credit reporting. Irene, shall we turn that one over to you to begin with? What does our audience need to understand about credit reporting or any new trends?
A lot of the things that are going on with credit reporting, there's been some changes over the last years that do make it a little more difficult for us even now, even not the things that are popping up, like they're talking about maybe not credit reporting on medical debts for a year. That's actually going to make things difficult for the patient. Let me tell you a few reasons why. So first of all, credit reporting on medical debt has always been confusing since data furnishers have to report an accurate first day delinquency. Now, the FCRA gives 3 ways to determine that. We're never going to be one of the first 2 ways. The first way is get a data delinquency directly from the creditor. The second way is get a data delinquency from someone other than the creditor that's accurate, maybe a billing company that the creditor uses. So we have to use the third way, which is basically it has to be a date that precedes the date of collections, and it has to be in our policies and procedures of how we figured that out and that our client agrees and that kind of stuff. And why is that so crucial? Because that's the date that the negative trade gets removed from the credit report 7 years later. So they use that date. But here's what makes it difficult with medical bills. When you have a data delinquency, what is it? I mean, this is one of the few bills we create that when we go and create the bill, we have no idea what the bill is going to be. I mean, even the doctor doesn't know what the bill is going to be. Nobody does. They might know what your copayment is. You might have a $20, $30, $50 copayment, but they have no idea. You're not going to go to the doctor and say, hey, you know, I know you're going to give me a strep test. I know it's going to be positive, and you're probably going to give me some type of shot, so what is that going to cost? I mean, that's not how we do this. We go in, the doctor will treat us, the bill gets dropped, which is what the medical industry calls dropping the bill. It goes to their medical billers, they code them, they figure it out, they send it in. So no one knows when they walk out of the facility what they owe. So a true data delinquency can't be right after the date of service. But what if that person has insurance? What if that person has secondary insurance, tertiary insurance? Is it after all that's processed? What if the person creates a payment plan after all that? Is it after 6 months when they defaulted? What if they don't have insurance at all and they created a payment plan and they default 6 months down the road? What if they don't have a payment plan or insurance and they never set one up? Is it 30 days from the date of service? What is the date? It's always going to be a very wishy-washy date, so we have to use that last thing. If you're going to expect insurance to pay and you're going to bill somebody afterward, you have to use that third date to be the most realistic on what the most accurate data delinquency is. So it's got to be something you agree with our client. So what laws are they going to put in place with that? If you look at one of the laws, it's not even really a law. It's New York started it, and the credit reporting agency decided to adopt it for the United States, that they don't put anything on a credit report until 180 days from the date of delinquency. Well, back to that question, our date of delinquency may not be accurate. It's going to be reasonable as far as what we're practicing according to our client to make it benefit the consumer the most, and definitely before the date it gets turned to collections. It's not always going to be the true most accurate date of delinquency. So we have to make sure that what we're reporting is as accurate as possible and that benefits the consumer so it falls off sooner. If I wait for a year to put it on, what is the date they're going to have us use first date of delinquency? Is it going to be a year from the first date of delinquency if they go through with this rule? But then you also have other laws to be considered, like you got 501R. For hospital clients that are tax exempt, those 501c3 facilities, they have to follow the IRS 501R rule. It clearly states in the 501R rule that no extraordinary collection actions, which would be credit reporting, can be done until 120 days from the first post-discharge statement date. That's a totally different date than your date of delinquency. And 120 days from the first post-discharge statement date is going to be probably sooner than 180 days from the date of delinquency. It becomes very complicated to make sure that you're meeting all these laws. Also included with that 180-day thing that happened a couple of years back, you're not allowed to report medical debt that's paid by insurance. Now we have to keep track of that, and that's always been a question, because I know Tim could agree, medical debt that we get from our medical provider clients are after insurance is exhausted usually. What we're collecting on is the patient responsibility. So you have to think about, well, how is your agency really going to define that the way it's stated in the rule? So is it basically, are you going to be, if it was paid ever by insurance, or was the last payment by insurance? So we all have to adopt our own way of understanding that, our interpretation of that, and decide, okay, this has to be removed from the credit report because insurance paid at one point on this, or is it, like I said, the very last payment, which could be a whole different thing. Most of the bills we get are after insurance. These are all things we have to consider as far as all the dates. Now, there's already a whole bunch of safeguards in place to make sure that patients have time to contact. There's a whole bunch of things to do, but I want to put one more thing on that 1 year that worries me. That 1 year reporting, even if it's from the date of delinquency, whatever it is, if they go with the 501R first post-discharge statement date, I don't care. 1 year later is usually past the timely filing period for insurance. Now, we often get accounts that do have insurance. The patient may have never supplied it to the medical provider, and we may be able to contact that patient, get that insurance information, get it to our medical provider client, and have the insurance billed within the timely filing period. Because once you're outside the insurance timely filing period, which is, they range, they could be 3 months, 6 months, a year, 18 months, we find normally they're about a year. But if we file after that year, they're going to deny it, and they don't have to pay a dime. Nothing has to happen with that bill, not even the contractual adjustment. They don't have to consider it at all. how does that benefit the patient? Because if I have a patient that's waiting a year before credit reports that I can't contact, I have invalid contact information, I skip trace and I can't find them, it goes on their credit report, they go to apply for credit, they find it on the credit report, they contact us. We realize, well, you did have insurance, it's within the timely filing period, we get the insurance information, we bill it, voila, everybody wins. We get a nice deep pocket insurance payment, the medical provider gets some money on their bill, and the patient owes less money. But if it's outside that timely filing period, they can give us information to the blue in the face. The insurance will always deny it. So how is it benefiting the patient to put that 1 year rule on before it goes in the credit report? I'm not sure how it helps the patient. Tim, do you have anything on that? Do you have anything you want to add to that?
Well, first I'll say, I think we found your hot button. Don't ever ask Irene about credit reporting. No, all great points. And from my standpoint, this question relates to the new HR 5330. And the talks in that are delaying the credit reporting by 1 year, and then there's also a version of 2 years. The biggest problem that I have with this is I don't have a problem with credit reporting and not credit reporting. In fact, probably about 4 or 5 years ago as a company, we recommended to our clients not to credit report just because it's less dispute work for us from a lawsuit standpoint. From all the studies that we've done, it had some sort of an impact, but it was such a small impact. The problem I have with Washington telling us and telling healthcare providers that we can't credit report is now the consumer or the patient is going to understand this. We talked about how hard it is to be able to talk to a patient today and communicate this. Now, if they know there's no consequences and not paying that for a year to 2 years, they're basically getting a 1 or 2 year loan at no cost. I think the other thing that's under scrutiny right now in healthcare is the whole legal collection process. We won't get into a whole lot of that because that could be a whole other podcast, and I think we both have a lot of things to say about that. But if the idea behind that is providers aren't allowed to file suit to collect their money, and now they're going to be delaying the credit reporting for a year to 2 years, it gives no incentive unless you're just a good person like many of us are, but unfortunately there's not a whole lot of those out there that want to pay their bill because they understand they owe it. But if there's no consequences, it's going to be really tough on healthcare providers, and then it all ultimately comes back to all of us because if they don't get paid, all that is, I mean, healthcare costs are already high enough today, but there's only one person that's going to end up paying for that, and that's going to be the person that, like us, that will actually go out and pay our bills. So I think that's the big issue that I have for this one.
Good point, Tim.
Well, Irene and Tim, thank you so much for all that wonderful information. We appreciate it. And just real quick, before we close, I want to remind everyone that news and information related to the accounts receivable management industry is covered extensively in Collector Magazine and in ACA's daily electronic newsletter. Both are available on our website at www.acainternational.org. This podcast and ACA's other podcasts are available on ACA's website or wherever you normally listen to podcasts. Thank you and have a great day.